Constitutionally speaking, the politics of constitution and everyday speech is about our constitutional consciousness, the consciousness which is very necessary to be an Indian. We should act and speak according to the Constitution of India, which has given us noble ideas like liberty, equality, fraternity, and justice. Do we think our constitutional values when we live and speak in a society? How do we speak according to the constitutional values? Why is it necessary to speak in a constitutional way? We will discuss about such normative questions in the webinar today. I would like to introduce our speaker today, Professor Sumit Bhatt. Professor Sumit Sir is an associate professor and an executive director, Center on Public Law and Jurisprudence at the Jindal University. He is a lawyer, academic, and activist known for his scholarship and advocacy on LGBT and Dalit issues in India. Professor Sumit obtained an honours degree in law and arts from the National Law School of India University, Bangalore, and master's degree from the London School of Economics. He then graduated from the Doctor of Judicial Science program at the UCLA School of Law. Professor Sumit has worked with United Nations Development Programme, Care India, Commonwealth Human Rights Initiative, and the Aman Trust. He has also been a fellow with the Transnational Law Institute at King's College London, research fellow at the Columbia Law School, human rights fellow at the University of California, and a fellow at UCLA School of Law. He is also an artist whose work includes sound sculpture and photo performance. His work has been exhibited in India and the United States. It is our pleasure to have you with us, sir.
Pleasure to be here. Thank you so much.
Going on to introduce our principal ma'am, Dr. Hemlata Bagla. Dr. Hemlata Bagla ma'am is a senior dean, science and technology of HSNC University. She's an award-winning nuclear scientist, administrator, and educationist. She has published more than 50 research papers in national and international genres, including 6 publications at NASA Astrophysics Database. She has not only been with us for the past 4 years, but also is an associate professor of chemistry department for the last 16 years. She is an excellent orator and believes in lifelong learning. Her determination and caring persona is taking Casey College at the HSNC and the HSNC University to greater heights. I would like to request Principal Ma'am to address us.
Stuti, I don't think that the principal ma'am has joined us yet. So I think that we will invite Professor Padi, Professor Samajit Padi. Sir, are you here? So ma'am has not joined, no?
Principal ma'am isn't with us right now over here. So I'd like to introduce some Padhi sir, who is Vice Principal of KC College, Assistant Professor, Commerce Department, and I would like him to speak a few words. Padhi sir, am I audible to you?
Padi sir, you're not audible to us.
Padi sir, can you hear us?
Yes, sir.
Our
He's
Vice
completing the.
Principal Padi sir is here, so he will be representing our college on behalf of uh, HSLC University and KC College. As Principal Ma'am is not here with us because of some meeting, Ma'am couldn't join us. So,
No,
uh,
no.
our,
Bhutan, can you hear me?
yes, yes, sir.
Yes,
I
Yes,
can
yes,
hear
sir.
you.
yes, yeah. Okay, fine. Let us not go into so many details of introductions and everything. I think today's webinar is there, and we are very much keen to listen to Professor Sumit Bodh. And and I don't have this illusions that I know anything about the constitutions, and so also is there. I whatever little I know about it, because somewhere the interest was there for constitution. And when we talk about the constitution normally, then as a student of commerce, like when I was also in the graduation, so that time we know that there's an article of association of a company, and whatever the article says, the company has to follow that. That means the power of the company is drawn from, the authority of the company is drawn from its articles of association. And somewhere uh, I draw the same kind of parallel when we are talking about a government. We are talking about different organisms of the government. We are talking about different parts of the government, and we are the interrelationship of the government. So it all, the power, the functions, everything they draw from the constitution itself. I am very proud to say that yes, India has got a very good constitution and one of the best constitution. I cannot say, because I am not the authority, can say it's the best constitution in the world, but I can say it is one of the best constitution in the world. Okay, it has also experienced some hiccups in between when we are talking about like in 75 when the emergency was there, then also the constitution came under a fire, like how emergency so easily could be declared over there, and how the amendments can also be made. Then I think in present generation the students will have something to say about the constitution when we are talking about the abrogation of article 370. And I think that is their glimpse. And in between 75 was a watershed when people really understood constitutions and all those, and maybe that was a political awakening of India, one can say. Maybe it is one can call it as a silver lining in the cloud, dark cloud of emergency, and people suddenly became very much aware of what rights are there, what duties are there, and what constitution is all about. But again, like as citizens of India, we must have at least the understanding of the spirit of the constitution. And I am very much kind of say on behalf of our principal, Dr. Hemlata Bagla, and all the faculty members and the students, I would like to extend a very warm welcome to Mr. Sumit, Professor Sumit Bodh, to have delivered this talk today, and he's consented to come over here. And my special kind of say thanks also goes to Professor Bhutant here, who has thought of this day, not only about this day, but at least this topic. So again, I say we should be having some interaction on the constitution all the time. So at least the future citizens which are coming out of it, they know about it. They should not have any illusion of what a country is about. And it is not a place where wanton things happen, and wanton things should not be allowed to happen also. Something has to be there enshrined in the constitution, and then only it gets a validity in the whole country. And nothing can be much more kind of say fruitful than having such kind of seminars, and maybe a small glimpse of the constitution or at a time. But some kind of interest is generated in the students, and they may have their own studies. They can have this inquisitiveness to study the constitution and understand the spirit of the constitution. My thanks and my warm welcome to Professor Bodh once again, Professor Sumit rather, I will say once again. And Professor Bhutant, we can just continue with the program. Thank you very much.
Thank you, sir. We will keep your words in mind and do the necessary. I would request Rudan sir to address us now.
Thank you, Stuti, and thank you very much, Padi sir. Sir has really brought out some very important points on constitution. This was such an elucid and such a comprehensive talk by Padi sir about the Constitution of India and the spirit of the Constitution of India. We are really glad that as KC College, we are celebrating Constitution Day in our college, and we have got a very learned personality, which is Professor Sumit here with us. So, without taking my time, I would request to Stuti to continue with the talk, and let us listen from Professor Sumit as soon as possible. Please carry forward this, Stuti.
Yes, sir. Thank you. I would request Professor Sumit, sir, to address the webinar now.
Thank you very much, Vratan. Thank you very much, Soumya, Stuti, for organizing this. I'm very grateful to the Political Science Department of the KC College for organizing this event, for having me over. Thank you, Professor Padi, for your opening remarks. And of course, a kind of noting a moment in the constitutional history of India as that of 1975, the emergency, which tested various constitutional provisions and guarantees in such a way that it brought to fore not only some of the underlying spirit and the vision of the Constitution, but tested that vision, tested those guarantees. And over time, of course, the Constitution has evolved not only in the text of the Constitution, but also the doctrinal understanding and the judicial interpretations over what we know as the decisions of the judiciary. So today, as we look to the title of the webinar, we're calling it Constitutionally Speaking, Politics of Indian Constitution and Everyday Speech. And when we are saying everyday speech, one way of understanding this would be within the contested domain of freedom of speech and expression. Although that's not what informed the making of this title. What informed the making of this title was the way in which we understand everyday speech as in routine conversation. So keeping the idea of that routine conversation, we would try to have the content of this webinar as well in a language and in a content which is accessible, which is light, which is easy. At the same time, is flagging some of the moments of significance within the constitutional discourse, both as it occurred as a point of genesis, as the late 40s of the previous century, and as also over the past 70 years in a post-colonial India. So what I'll be doing is speaking extempore and broadly drawing from eclectic sources. And what do I mean by that? Typically, talks like these, especially as we commemorate the Constitution Day, are often delivered with a scripted speech, and that scripted speech draws from the constitutional provisions, draws from the court decisions, draws from scholarship. We would be doing that, but we would also be, because what we are trying to do is to bring an idea of constitutionalism to what we understand as everyday, day-to-day conversations or routine conversations. Then what we want to also draw from, in addition to the formality or the formal sources as those of primary materials, secondary materials, we will also be drawing from experiential knowledge from within classroom instructions, especially here at the Jindal University, where I instruct courses in constitutional law. And we know that classroom spaces are mini laboratories of ideas. And this cuts across all disciplines. When we deliver curricular materials, when we discuss these materials, and the kinds of comments and questions that we bring to our classroom sessions then informs the way in which that discursive understanding of any discipline is communicated, is delivered, is received, especially to a younger generation, which is receiving those ideas in an introductory manner. With that, perhaps this webinar would not be an apt introduction to constitutional law or the broader constitutional discourse. What this would be is a broad, very broad commentary about the ways in which constitutional law discourse is understood in a common language, in a common vocabulary, conceptual frameworks. And we would be drawing from some of our personal experiences. We could draw from media news and current affairs. A lot of what is going on around us is testing the parameters of the Constitution. And anytime we pick up any newspaper, any major national newspaper, we know that front page news is often on and about constitutional law. Those are the news and current affairs that we are familiar with. The incidents, the ideas that circulate, but also within popular culture as that of films. For example, representation and the law is an important interface between the legal understanding and a popular understanding. And we know that films like films like Ore Oru Gramatile, a Tamil film, was brought to judicial discourse in the landmark decision of Rangarajan versus Jagjeevan Ram, a Supreme Court decision of 1989. And these are the ways in which some of the constitutional ideas are not only represented within popular culture as films, some of those contestations are then decided within the formal domain of the judiciary. So more broadly, the constitutional law discourse, more broadly, the text of the Constitution, court decisions, scholarship, these are some of the eclectic sources that we will be drawing from. But our single point of entry for this webinar would be a speech delivered by the chairperson of the drafting committee, Dr. B.R. Ambedkar, and this is on November 25th. So today is November 26, 2020. And this speech was delivered by the chairperson of the drafting committee, Dr. B.R. Ambedkar, on November 25th, 1949, in the Constituent Assembly. So what we'll do, that will be our point of entry. It will be our point of departure. It will be our point of entry in the sense that we will refer to select excerpts from this speech, some of the main points, highlights of this speech. And from there, we will see how this speech continues to be relevant over time to come in the span of 70 years to follow. And that's an important, crucial moment of genesis. That is often also a very common reference point when we mark the Constitution Day. Often it is this speech that is brought to reference. So some of us might already be familiar, and we circulated a little link, and it's available freely on the internet. It would be good, those of us who prefer to have some kind of a text to keep for reference, then that's one text that we would be developing from. But before we get to that, and because this is delving into a routine conversation, and what could be more routine of a conversation as a question as where are you from? Often when we meet people in a gathering, or it could be a social gathering, or it could be getting to know somebody, often an opening question is where are you from? And this question could come from a place of completely harmless place, in the sense that it's a conversational question. Or it could be motivated in the sense of trying to gain a sense of any regional location. And that sense might be combined with prejudice. For example, the inquiry could be so posed, which might be prejudiced against certain parts or regions or states. For example, there might be any prejudice against somebody who might be from Punjab, and therefore the inquiry, where are you from, resulting in an answer as I'm from Punjab, might cause some prejudice to the respondent. So when I'm often posed this question, I say I'm from my mother. And that's a deliberate kind of evasive way of not replying to this question, because this question also undertakes a kind of a racist tone. In other parts of the world, for example, we know that there are typically what we understand as a right-wing politics, in which there are sentiments of resentment toward anybody who may have moved from another part, and therefore offensive statements as go back to where you came from would start with an inquiry as where are you from, and location, or why are we talking about this? Why are we talking about this general conversational question? Is because in the Constitution of India, there is a provision as Article 15, which prohibits discrimination on grounds of place of origin. And yet we know that, especially on campus, it's a very, very common way of bracketing our peers, in which on campus very quickly we locate our peers in terms of whether they are from Tamil Nadu, if they are from Bengal, and then there could be a range of offensive or not so offensive references that we keep to this kind of bracketing that we do in our own mind. So when we talk about more routine conversations, especially as we develop more robust commitments to constitutional ideas, to constitutional aspirations, to constitutional vision, then even in our routine conversation, we might note ways in which we might, breach some of those constitutional ideas and aspirations. And the reason why we are mentioning, we are flagging Article 15 is because a provision includes both what we know as vertical equality and horizontal equality. That is to say that it isn't just the state that is accountable for the fulfillment of this guarantee of non-discrimination. Rather, this guarantee of non-discrimination could be extended to non-state parties as individuals as well. And that is quite a characteristic feature of the Constitution of India, in which equality is understood both in terms of vertical and horizontal. Another common reference that we make when we talk about the Constitution is this reference to we the people. And we know that the preamble, of course, begins with the text, we the people of India having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic. A question that could be posed to this kind of a formulation is as to who were the people who were present who would have so resolved at the time. Were any of us there at the time of the making of this text? So when we say we the people of India, is that a rhetorical invocation? Is that what we know as a legal fiction, in which it isn't so that we the people of India, it isn't so that all the people of the India, even at the time, gathered together and solemnly resolved? It would be a majority of those inhabiting the subcontinent might not be familiar with the text of the Constitution as such. And yet in an invocation as we the people, there is often a presumed plurality, or there is a presumed speaking for the other. And we are flagging this because our understanding of we the people should not silence any dissenting voices, should not silence any voices of opposition. And at a later point, we will tie it up with ideas of constitutional morality, because we know that constitution and constitutionalism doesn't simply mean an authoritarian will of the majority. Democracy doesn't mean a will of the majority such that it prevails upon minority. Therefore, when we have any kind of a commonplace understanding of the constitution, and we have any kind of a more routine conversational understanding of we the people, and as much as it might also be partly sentimental, in which we might have sentiments of both patriotism, commitment to the Constitution, and therefore we might not stand back and ask ourselves, what is this supposed plurality? What is this we? Who is this we? And does it actually and really include me? And when I'm included, is there any possibility for me to dissent? Is there any possibility for me to voice my opposition? And this opposition, this voice of opposition, this minority view becomes very important as we understand what we know as a constitutional morality. So it's almost 40 minutes past 5. And before we get into the select excerpts from the 1949 speech, and at that point, we are going to share the screen at our end. Another commonplace kind of reference that is made when we speak of the Constitution is that of founding fathers. And this might be true of the American Constitution, because we know that the making of the American Constitution included only men. When we talk about the Constitution of India, and this is, I'm borrowing from common usages within our classroom instruction, sometimes we say founding fathers. And when we say founding fathers, what we are discounting is the participation of women in the Constituent Assembly. So as much as, especially those of us who do comparative constitutional law, and might have that reference, that easy reference that is made within American constitutional discourse, which would be entirely apt because because the makers of the Constitution of the United States were all men. But it isn't so applicable when we talk about the Constituent Assembly in India. So we do a bit of disservice to the participation and the role played by not only fathers, but also some mothers. And in any event, there may not be a requirement for us to have such familial and relational kind of invocations to make as that of fathers or mothers. We might simply, in more generic language, say framers of the framers of the Constitution, as those who were the founding members or who were the founders of. So those are more generic ways of talking about Constitution and constitutionalism. So this is just a very quick set of references to more routine conversations and more routine use of language that comes up in constitutional law discourse, and that could be understood. And we, in the course of this webinar, we would welcome more of such understandings that we might have, especially as we open to comments and discussion segment to follow later during the session. So at this point, what I'm going to do at my end is share screen. And with that, what should appear at the screen at your end would be a cover slide, which would say the title of this event. As we are saying, as we're looking at the title of this webinar, Constitutionally Speaking, Politics of Indian Constitution and Everyday Speech. And in brackets, we have placed routine conversation, because like we said, speech could be understood as a discussion of constitutional understanding of freedom of speech and expression, which is entirely topical, and we could partly get into those discussions as well. So here is a speech that we are referring to from 1949, and we'll begin with this question. Why did the Communist Party and the Socialist Party condemn the Constitution? So, especially as we are locating the politics of the Indian Constitution, it is very important to know certain points of fissures that were there right at the Genesis moment. And these points of fissures is something that Dr. Ambedkar is addressing before the Constituent Assembly. So, one, when we read this speech, we want to locate it, that this is for an audience, and the audience is the Constituent Assembly. We could ask that, is it only for the Constituent Assembly? Because we know a historic moment is this. Is being recorded and is being talked about in this webinar. So clearly, it isn't so located in time as in 1949 and for a limited audience, because when the speaker, Dr. B.R. Ambedkar, is speaking even in the Constituent Assembly, the speaker is aware that this is a historic moment. And the invocations that are being made of this Genesis moment would be referred over time to come. So that is one significance of locating this speech. Also, at the earlier parts of this speech, there is information about the duration, the time duration that this process took, starting in 1946 to 1949, over several sessions. And the kind of details that the speaker, Dr. Ambedkar, is giving to us, there is a reason. The reason is that of an allegation that the constitutional process, that the Constituent Assembly, that the drafting committee took way too long for the making of this constitution. And the speaker, Dr. Ambedkar, is addressing that by giving a comparative understanding of the constitutions of the United States, Australia, and saying what is the content of these and what is the content of the number of amendments that it took for the Constitution of India to come about, and is directly addressing any allegation that would be to say that the constitutional process had been slow. And after then, the speaker addresses this question as to why did the Communist Party and Socialist Party condemn the Constitution? And this condemnation is because the Communist Party had wanted a constitution based on the principle of dictatorship of the proletariat. What does that mean? That there was an ideological understanding that sought to locate power within the working masses. And this ideological opposition to the Constitution resulted in the Communist Party condemning the Constitution. This Genesis moment, these fissure points will continue to play out in some of the landmark decisions to follow after 1950. And for us to understand those landmark decisions, which don't always give a lot of the ideological understanding, it is important for us to know what is happening at this point of Genesis. And what is happening at the point of Genesis, the fissure points, is something that would continue to play out. Why did the Socialist Party condemn the Constitution? The Socialist Party had wanted freedom to nationalize or socialize all private property without payment of compensation. Now, this is something that would play out in the very early land reform cases, as that of Shankari Prasad, Sajjan Singh, Golaknath, Keshwananda Bharati. These landmark decisions would also then be the ground for the emergence of what we know as the basic structure doctrine that attempts to grapple with the parameters of constitutional amendments. But what follows in these landmark decisions, or what follows in the context of land reforms, is precisely the freedom to nationalize or socialize all private property without payment of compensation. So this opposition of the Socialist Party, this condemnation of the Constitution of India by the Socialist Party at the time, is something which isn't just located in a point of genesis. Rather, it is something that would continue to play out over decades to follow. Something else that the Socialist Party had wanted was that fundamental rights must be absolute and without any limitations. Now, We know that even our reading of Article 19, we know that freedom of speech and expression is limited by reasonable restrictions. So when we understand freedom, when we understand liberty, it isn't absolute liberty, it isn't absolute freedom, because any constitutional understanding of liberty is located within what we know as reasonable restrictions. The next question that we could pose of this text is, what does Dr. Ambedkar mean by principles embodied in the Constitution are the views of the present generation, and what is he getting at? Partly, one is to address the condemnation of the Communist Party and the Socialist Party, and to say that the text of the Constitution, as it emerges now, is the views of the Constitution. A disengagement with the political process may not be the answer. And if this condemnation and this opposition is something that engages with the political process, then who is to say that the very text of the Constitution could be changed over time? So this is a kind of a reassurance to the opposition, to the opposing views, to those who are condemning the Constitution at the time, to say, engage with the political process. And that engagement with the political process would be such that there would be a certain composition of the parliament that could then amend the Constitution. So when Dr. Ambedkar is talking about principles embodied in the Constitution, our views of the present generation, what the speaker is saying is that the amendment of the Constitution is a facile procedure. Relatively speaking, the amendment process, the amendment procedure of the Constitution of India is facile, or to say it differently, is easy enough. And that is something that, that we see, say, in the 100+ amendments to follow. So the Constitution of India has undergone a number of amendments, and that is because the procedure for amendment is something that makes it possible for the text of the Constitution to be changed. As we note this ability of the Constitution to be amended, over time, especially as we understand the basic structure doctrine that grapples with how much of the Constitution can be amended. Can all of the Constitution be so amended that it changes form, that it changes spirit, that it is entirely different from what it was at the point of origin? Then we know that there is the basic structure doctrine that attempts to locate a basic structure, and the doctrine would be to secure that basic structure such that that which is basic to the Constitution cannot be changed. Why is Dr. Ambedkar talking about federalism, and what is he getting at? So here is where we know that there is this allegation that too much centralization and that states have been reduced to municipalities. When we understand federalism, we know that there is the federal structure of the Constitution of India, or the Union of India, is such that the union prevails over the state units. And what do we mean by that? That the relationship between the states is not balanced and it's not equal. The union prevails over the states in the sense that in the very making of the Constitution, in the very structure of the Constitution, this kind of union prevailing on the states is something that is built into the constitutional provisions and is also built into the doctrinal understanding. But this is not inadvertent. It is not a matter of chance that the federalism, that the scheme of federalism is such. This is something which is built into the Constitution because of the aspiration of what we know as unity. At the time of the making of the Constitution, we know that the task of unifying multiple various units as princely states and regions and provinces was a task that required a commitment to the unity of India. And this unity of India, for it to be secured, the union had to be strong because relative greater strengths to the state units could jeopardize this project to be, which was an attempt to unify variously located princely states, provinces. So here, the speaker, Dr. Ambedkar, is justifying the scheme of federalism, which allows the union to prevail over state units. But there is something else which is at the core of this, is the significance to village as a unit, and the skepticism that the speaker, Dr. Ambedkar, had of villages as locations of power, because as much as villages or smaller units of municipalities could be places of power, historically, especially in the ways in which the caste system had played out, which was such that it was steeped in practices of inequality, violence, and discrimination. Therefore, that might be, something that informs Dr. Ambedkar and the skepticism of locating power at the units as the villages and municipalities, rather to locate that power at the union. And this is also something that places the speaker, Dr. Ambedkar, in ideologically, in opposition to some of his peers at the time. What is Dr. Ambedkar's alert about India's independence? What would happen to her independence? So one way in which the speaker is alerting about this independence is that, look, this independence is fragile. And why is it fragile? Because the composition of people is such that it is divided on the lines of region, on the lines of languages, on the lines of cultures, on the lines of caste. And this independence, therefore, as precious as it is fragile because of the internal divisions that there are. So, given that there are internal divisions, given that there are internal inequalities that would jeopardize an emerging independent India at the time, it isn't just a lament, because Dr. Ambedkar is also pointing to certain safeguards and saying that the democracy is at stake, in which, as much as the Constitution attempts to create universal adult franchise and a democratic constitution, but it is something that would have to be safeguarded. And with that, the question is posed is, if we wish to maintain democracy, not merely in form, but also in fact, what must we do? So it isn't just a lament in which the speaker is saying that, look, democracy is fragile, or this independence is fragile, but the speaker is giving clear prescription as to, if we wish to maintain democracy, not merely in form, but also in fact, what must we do? How do we maintain democracy? First, prescription, and this is the part that is often quoted when talking about this speech, talking about constitutionalism, especially on Constitution Day. And when we get to this part, we know the context of. So before we talk about what must we do to maintain democracy, we must understand, why is this democracy fragile in any way? Or why is it that this independence is fragile? And why is it that the speaker, Dr. Ambedkar, is alerting to the possibility of losing freedom, of losing democracy, and with that also giving a prescription as to what must be done to safeguard this democracy? First, hold on fast to constitutional methods. What does it mean? abandon bloody methods of revolution. 2, abandon the method of civil disobedience, non-cooperation, and satyagraha, because these methods are nothing but the grammar of anarchy. Now, as much as we want to receive it, we also want to trouble it a little, because as we hold on to constitutional methods, and with the supposition that there is a rupture in the British Empire and the emergence of a government of India, and that rupture would be such that the domination and the injustice of the empire would be presumed to have come to an end. And we know that more critical studies in post-colonial studies would inform us that the government of India to follow is a continuity of the governmentality of the past, and therefore the government of India over time did not make a rupture from the past. Rather, it continued some of the characteristics of the oppression of a British colonial government. So then, if there is a supposition that with the coming of the Constitution, there would be a rupture from the past, then when we hold on fast to constitutional methods, especially as we develop a critical understanding of abandoning protest. And one way in which this came up conversationally was previously at Shaheen Bagh. And when we were planning a talk there and we were speaking to the organizers, we were thinking of bringing this speech to conversation. And some of the organizers of Shaheen Bagh were questioning as to what would this kind of, this very first hold fast to constitutional methods mean if constitutional methods do not yield social justice, do not yield justice. So those could be ways in which, as we understand these ideas, we also trouble these ideas and understand the premise or the presumption, which is the underlying basis for making this holding on fast to constitutional method. On gratitude toward great men, and this is something that the speaker, Dr. Ambedkar, will alert against hero worship, that in politics, bhakti or hero worship is sure road to degradation and to eventual dictatorship. And this isn't just at the time, although it could be a matter of, we could speculate as to who the speaker might be referring to, especially any leader at the time who might be so charismatic, who might be such that they would be worshipped. Over time to come, we know that this is an alert in political mobilizing, so that we don't blindly follow. So here, the hero worship is not against offering our allegiance to any ideology or to any, but it is to blindly, an alert against following anybody blindly. Third and last is we must not be content with mere political democracy. And this is going to be our broader point of, departure from here, as we understand the difference between political democracy and social democracy. So when the speaker is saying, Dr. Ambedkar is saying, we must not be content with political democracy, then what is this social democracy? What is this idea of social democracy that is being invoked? And that becomes clear in the text to follow. But before then, there is an invocation of this union of Trinity, something that Soumya talked about in the opening remarks, which is that of liberty, equality, and fraternity as principles of life. So here is a quote that is often very popularly, it's very popular, and it's something that is often referred in this speech. And we quote, "We have in India a society based on the principle of graded inequality, which we have a society in which there are some who have immense wealth as against many who live in abject poverty. On the 26th of January 1950, we are going to enter into a life of contradictions. In politics, we will have equality, and in social and economic life, we will have inequality." What is this equality in politics? The equality in politics that is being referred here is one person, one vote. So, with the aspirational universal adult franchise at the time, which the rest of the world is a little wary of, with the levels of education in the subcontinent, and yet at this time, there is the guarantee of universal adult franchise. So, with that universal franchise, there would be a parity of vote, that there would be one person, one vote. That political equality would not correspond with the deep and pervasive social inequality where various individuals would have different worth. Some would be more valuable and others would be worthless. So, this social equality or this social inequality that places differential levels of worth upon individuals, that it values some more than others, that social inequality is something that Dr. B.R. Ambedkar is alerting the audiences that we must not be content with mere political democracy. We must have a robust sense of social democracy. All of that sounds good in rhetoric. Now, is there anything that the speaker is telling us how to do this? Or is it only just a lament that in the political domain, there will be equality as one person, one vote, and in the social domain, there is inequality? And this hardly seems like, we know, that there is a kind of a duality, multiplicity, series of contradictions, the way in which we live our life on a day-to-day basis, in which we present ourselves differently, and we know how to behave in what manner with whom. So it is something that we almost imbibe into our personalities. And is there anything that the speaker is saying how to undo this social inequality? Or is it only just a matter of commentary at the time? That is to say, that when the Constitution, with the promulgation of the Constitution on 26th of January 1950, we are going to enter into a life of contradictions. And this text we are underlining here because often when we invoke, when we refer to this quote, it is this part which is most commonly, which remains in our memory. This is a life of contradiction. But is it that the speaker is just lamenting and saying that, it's a life of contradiction? Or is there anything prescriptive that Dr. B.R. Ambedkar is telling us as to resolve this contradiction? And this resolution of the contradiction is sought to be done in what we see immediately above this quote, which is this union of Trinity: liberty, equality, and fraternity. So at this point, it's 6 minutes past 6. We'll take a short break so that, allow this to think about this. And when we come back, we are going to explore ideas of liberty, equality, fraternity in the landmark decisions to follow. So, which is why we said for our webinar today, a point of entry and a point of departure would be this speech of 1949. And after having come to this almost iconic quote which is alerting us about this life of contradiction, but not just alerting and lamenting that life of contradiction, is also giving a clear prescription for us to resolve the contradiction. And that contradiction can be resolved by this union of Trinity, by a combined reading of liberty, equality, and fraternity. We'll take a 5 minute break here, and when we come back, we will continue our discussions.
Sure, sir. Thank you.
Stuti, am I audible? Stuti, may
Yes,
I
sir,
take
you are.
a minute or so?
Yeah, sure, sir.
Yes. First of all, thank you very much, Sumit, for this first part of your speech. It was really a brilliant presentation of the Constitution. I am not going to summarize this right now, and I am not even attempt to do this later on. But yes, we are learning in our classes also. We are learning about the Constitution and the purpose and meaning of the Constitution. So I think that this is a very important talk in that context, first of all. And now we are going to see next how and where exactly Professor Sumit takes us in his talk, where we are talking about the speech, constitutionally speaking, and it is somewhere about the speech and about the constitutional actions. So I would like to just add a note on Professor Sumit. He has been a dear friend, Professor Sumit, and I would just like to add a note on Professor Sumit that he is, of course, a learned man. We can see his degrees from various places. He has this academic and educational experience, of course, he has. But Professor Sumit is a gentle person. Professor Sumit is a kind and dear friend. We can say that he is a person who is an embodiment of fraternity, which is a very important part of this Trinity which Professor Sumit was talking about. And I think that an educated person must be humble, must respect every other being. And in Professor Sumit, we can see these aspects, and I like this very much in Professor Sumit, which he carries around. He has got this charisma and so many things. I won't extend my speech here on this, but I would really emphasize on this part, which is the attitudinal democracy. Democracy, we are discussing about democracy here, but democracy does not only exist in the parliamentary form or in elections. Democracy also exists in our attitudes, in our behavior, in the respect which we give to each other. So thank you again, Professor Sumit, for being here with that gratitude and with that respect for us all. We are really looking forward to learn more from Professor Sumit here. Now I would like to give this to Stuti to carry this forward. Stuti, please take on.
Yes, sir. While we're on a break, there's a special student that we have from our college from the first year degree, and she would like to keep forth her opinion. So I would like to invite Rupali to speak.
Rupali, yes.
Good evening, everyone. My name is Rupali Prajapati. I will be speaking about the right to education, right to freedom, right to freedom of speech. Is one of the most fundamental rights of the Indian Constitution. It is because of the prevalence of the freedom that makes democracy purposeful. Right to freedom generates liberty and expression of speech, association, etc. It leads for people to criticize to working of the government and voice their opinion against those people which threaten our rights of the citizens of our country. Along in that, it is the responsibility of the citizens to use it rightfully without hurting any kind of sentiment. We all are people and our belief and the things which make us people to weigh our should not be used as insight just because someone else's views is different from ours. We need to inculcate tolerance, casual discussion, even in the most casual discussion about politics, religion, or literally anything. We need a understanding of the concept of talking gratefully and protesting peacefully for our rights as people of citizens of our country. We need to try empower and identify every individuals not because we are living in the democratic country and also because that is their first right as the human. Treating a human like he or she should not be taught to us by the constitution. It should come to us naturally and as humans. Thank you so much.
Thank you, Rupali. We really appreciate your opinion.
Thank you.
Sir, I think we'll wait for Professor Sumit.
Oh, I'm here. I was listening to Rupali. Thank you very much, Rupali. That was wonderful. Especially as we understand free speech, and as Rupali said, free speech doesn't mean hurting anybody. That locates an understanding of free speech, liberty, with what we know as deep and pervasive forms of inequalities and violence. So, for example, when we understand hate speech, which is speech which is targeted at certain groups, certain people, say, which is certain caste-based slurs, then we know that that doesn't count as free speech, and the restrictions on speech through what we know as hate speech are valid restrictions. So right there, what we have is an interconnected understanding of liberty as that of free speech, and equality and inequality. So when we understand liberty, we keep sight of inequality. And that is partly what the speaker, Dr. B.R. Ambedkar, was referring to in this Trinity as that of liberty, equality, fraternity. And fraternity becomes important because the very understanding of fraternity in India is located within caste-based inequalities at the time, and therefore an attempt to undo those inequalities, that there should be a fraternity, a community, a brotherhood, a sisterhood that would allow us to relate with one another without the shackles of inequality, discrimination, hatred that might be based on caste, various lines of ethnicities, linguistic differences. So the idea of fraternity then becomes very important. So before the break, when we left off with this prescription of Trinity, to undo this life of contradictions, when we trace the following constitutional discourse after 1950, then we come across what we know as a golden triangle in the famous landmark decision of Maneka Gandhi versus Union of India, which presents a understanding of liberty, which introduces the idea of procedural due process. Up until that point, liberty was understood more within the confines of what we know as procedure established by law. That is to say, that liberty can be limited, can be contained by the procedure established by law. And a landmark decision as that of A.K. Gopalan had held that this procedure established by law meant any procedure. Therefore, if there was a procedure that was established by law, that would suffice to curtail liberty. Departing from this contained understanding or this limited understanding of liberty, in Maneka Gandhi versus Union of India, and this is again around the time of the emergency that was brought to our notice by Professor Samarjit Padi, we know that this golden triangle attempted a relation between Article 14, 19, and 21. And what it sought to do was this interconnected reading of equality and liberty. That is to say that when we read Article 21 and the guarantee of liberty, it cannot be read in isolation. It cannot be contained by procedure established by law, any procedure established by law, because that procedure must be fair, just, and reasonable. And where did this fairness and justness and reasonableness of this procedure come about? It came about with the guarantee of non-arbitrariness as part of equality, right to equality in Article 14. It would not have been possible to introduce this idea of procedural due process in Maneka Gandhi if it wasn't for an interconnected reading of Articles 14, 19, and 21. One way for us to make a more historic reference to the point of genesis is when in the speech in 1949, the chairperson of the drafting committee, Dr. B.R. Ambedkar, is already informing us about this Trinity. So then what transpires in 2 decades and more to follow in Maneka Gandhi is something that has its foundations right at the point of Genesis. And as we read Dr. B.R. Ambedkar, we understand the foresight that there is in his speeches, in his writings, that remain relevant over time to come. So they are not located and fixed at a point of history that have then lost their significance. Rather, the significance of these ideas remain relevant over time as today. At the very early site of attempt at reform, as that of land reforms, we know is caught within constitutional challenges, because what these land reforms are attempting to do is to take over land from those who have excess land and to transfer that or to give it to landless people. Now, entirely worthy aspiration, but not so easy to do, because those whose lands would be taken away would understandably contest it and would contest it within constitutional parameters. And what then started to happen was that a number of these land reform legislations were placed in the ninth schedule, which precluded the applicability of Part 3 of the Constitution, fundamental right. Again, easier said than done, because a number of these cases, as that of Shankari Prasad, Sajjan Singh, Golaknath, up until Keshavananda Bharati, grappled with the question of the limits of constitutional amendments. And while allowing the state to plan and undertake land reform measures, what it resulted in is the emergence of what we know as the basic structure doctrine, which sought to retain and secure a certain structure that cannot be changed. And what is that structure? It remains a matter of interpretation that the honorable judiciary has provided over time, as landmark decisions as Minerva Mills, as M. Nagaraj, as Ashok Kumar Thakur, as I.R. Kolo. A number of these decisions have evolved the idea of this basic structure doctrine. But the point of genesis is the litigation, the sequential litigation that occurred because of that fissure point that there was in the demand that what was the Socialist Party asking at the time? The Socialist Party at the time was asking that, look, there should be access to resources, there should be nationalization, and this whole idea of free, fair compensation would undo the possibility of land reform, because the government just doesn't have that kind of money to purchase land from the landed class and to give it to the landless people. So that fissure point, that contestation plays out in the constitutional discourse to follow, and then it results in a doctrine as the basic structure. More recently, when we look to the landmark decisions as that of the National Legal Services Authority versus Union of India and the Navtej Singh Johar case, we know that what brings to application the Constitution of India is to areas as sexual orientation, gender identity. Now, as we understand the location, the historic location of the Constitution at the time, and we understand the basic structure doctrine, does it mean that the parameters of the Constitution are somehow so bound in time that they cannot progress? At the time, they might not have been an understanding of sexual orientation and gender identity as we know it now, but there is category as sex in Article 15, a non-discrimination category as sex in Article 15, that makes it possible for constitutional interpretations to occur in such a way that the National Legal Service Authority of India versus Union of India in 2014 recognized a transgender persons and also provided for affirmative action measures. And this recognition and this affirmative action measures, this directive for affirmative action measures was possible because of equality provision, and equal protection of laws is something that was invoked. So the broader generic guarantee of equality in Article 15, combined with the specificity of the non-discrimination category of sex, made it possible for an expansive, progressive reading of the Constitution. So only because sexual orientation and gender identity are not explicit in the wording of the Constitution at the time, doesn't mean that over time, there isn't the possibility for this Constitution to advance the rights of those constituencies that may have been so denied constitutional guarantees. When we invoke the fields of sexual orientation and gender identity, we also bring to reference the understanding of constitutional morality. When there is the litigation as that of decriminalization of Section 377, in defense of the criminalization carnal intercourse against the order of nature, public morality was invoked. That as much as this might be causing any criminality to a set of people, as making them undeclared felons, but because there is a public morality that is in favor of such criminalization should be retained. And this argument was set aside with the pursuit of constitutional morality, that if at all there should be any guiding principle for the state in pursuit of liberty, it should be constitutional morality and not public morality. What is this constitutional morality? And this is also something that Dr. Ambedkar had talked about. Although this is often referred to Dr. Ambedkar, this is also an idea that is borrowed from previous understanding presented by Grote. And as we understand this constitutional morality, it is allowing for a voice of dissent. It is wary of the authoritarian character of any majoritarian voice, so that there is an acknowledgement and protection of minority rights. So when we invoke ideas of constitutional morality, even what I was saying about how some of our peers during the Shaheen Bagh protest were skeptical of this prescription that is made in 1949 speech by Dr. B.R. Ambedkar, that we must give up, satyagraha, we must give up all kinds of protests, etc., because this is a grammar of anarchy. Along with that, there is also the idea of constitutional morality that allows a space of dissent, that allows a space of opposition. So when we understand the Constitution, when we understand constitutional methods, then constitutional morality is part of those constitutional methods, and dissent, minority views, is something that would have to be accommodated. And it is not a matter of anybody's fanciful imagination or anybody's presumed understanding, because there is an explicit recognition of minority rights within the Constitution of India, within Part 3, fundamental rights. So that is to say that dissent is important, and it is something that is within a constitutional framework, which is something that is acknowledged, it is something that is valued, and it is something that is sought. And therefore, this idea of constitutional morality becomes very important. And one way in which it has come to conversation, come to discourse, is in the context of what we understand as sexual minorities. But this is something that is more broadly, relevant to our understanding of minorities, be those linguistic minorities, be those religious minorities, sexual minorities, the protection that there is within the Constitution, something that is then valuable in our understanding of constitutional morality. So we are past 6, and at this stage, it would be good to invite some comments and questions so that we can have a more of an interactive session. So it would, with that, I'm going to hand it back to our organizing team. And I look forward to hearing more from our attendees if there are any. I'm a little wary of question and answer session. I like to think of it as comments and discussion, so that it doesn't have to be a question. And I certainly am not. I wouldn't flatter myself to think that I would have answers to all questions that are posed. So it would be good also to invite comments to contribute to this discussion. So with that, back to the organizing team.
Sure, sir. Thank you. Everyone, y'all are open to comment and post your questions, whatever y'all have in mind.
Is Soumya here? I would like to just
Yes, sir.
respond to Soumya.
Yes, sir.
Because we had a question from one of the attendees. So could you please
Yes,
read out
sir.
that question?
Yes, we have
We can have some discussion over.
Yes, we have a set of questions. I'd like to go ahead with. So we had one Kashmir, but I think that the person is not here right now for the session. So I'd like to ask a question on his behalf. His name is Izan Asif. So his question was, how come anyone who speaks up against the Indian government for committing human rights violation and torturing youth of Kashmir is placed under UAPA? I guess freedom of speech should be removed from the constitution. So it is like a question come a comment. So what are your views on the same, sir?
Do we want to invite more comments, or do we want to make it more dialogical?
Actually, there are a few more questions, but I think you, I mean, if you'd answer this question now, I could ask you the next ones later.
Say more question. We'll have a pool of questions and then we can get to those.
Okay, so another question was, does the constitution, is the constitution 100% suitable to the present conditions and situations, or is there a need for it to be modified? And if it needs to be modified, then which articles or which areas needs modification or changes? Then another question that we have is, when we talk about right to freedom of press in today's scenario, is the press using its power in an ethical way as for the benefit of the people? And we have two more questions. I'd like to ask, since you mentioned about Satyagraha, civil disobedience and non-cooperation movement, if I am not wrong, these are Gandhian ideas, the ideology of Mahatma Gandhi. So, I mean, do you think that, or like, in what way do you think that, as you mentioned, leads to anarchy?
Okay, excellent set of questions. And many of these are taking us to the contemporary sites of contestations, as that of Kashmir, as that of fake news. And those sites of contestations remain so, both within the parameters and the confines of the Constitution and outside. Now, here is where I'm going to borrow from an understanding within critical race theory by a critical race theorist as Mari Matsuda, who talks about multiple consciousness. And I find that very inspiring But the idea of multiple consciousness is that, especially as lawyers, as legal scholars, as advocates for law reform, we are required almost to have a duality, if not multiplicity, of engaging with the law. And what is this duality or multiplicity? Within the courtroom, we must speak of the transformatory potential of the Constitution. And authors as Kalpana Kannabiran, her father, K.G. Kannabiran, have talked about insurgent jurisprudence, transformative potential of the Constitution. That is to say, at all times, the Constitution, the text of the Constitution, the interpretations of the Constitution may not deliver at the time. It is a matter of persistent pursuit in which those constitutional ideas are sought, are pursued within the constitutional domains. And while successes may not follow at every point, that does not take away the possibility of accomplishing success within those constitutional domains. At the same time, the domain of politics is not limited to the domain of the Constitution, correct? Because as Professor Rutant was pointing out, when we understand democracy, it isn't only about a representational politics, as in to elect a set of representatives who are going to represent the people in the parliament or in legislative assemblies. Democracy as an idea is a value by itself, it's aspirational, it's something that we engage in differently. So the formality of the Constitution is one political engagement. And it serves us well to understand this engagement with the Constitution. At the same time, an inability to obtain the desired outcome should not throw us off the Constitution and constitutional processes altogether. And this is also something that we see within the experiences of anti-caste legislations in India and the various constitutional guarantees that there are. So some of the scholars say that, well, what have these constitutional guarantees achieved? What have these anti-caste legislations achieved when there remains this deep and pervasive caste-based inequality? There is a contradiction. Now, only because there has been a certain failure of a certain set of constitutional provisions or a certain set of anti-caste legislations does not mean that there should not be an engagement whatsoever with the Constitution and the legislative processes. So, especially as young people or as anybody, when we get disenchanted with the Constitution or when we get disenchanted with the legislative processes, often we tend to move away from, and our response can be that of disengagement. And that is where the idea of multiple consciousness of Mari Matsuda is helpful to me, where at times where I might have a critical perspective of the Constitution and the legislative units, then I know that I need to have an engagement and a disengagement. So it needn't be a complete and thorough disengagement. I need to be able to work with the given confines of the Constitution. And as Dr. B.R. Ambedkar in his speech in 1949 said, that engage with the political sphere, engage with the political sphere, get into the political domain, get into the parliament, get into legislative assemblies, and make the change. So then what there is on our parts is to engage more actively within the political domain, and especially those parts of legislations as a UAPA that would result in certain oppression, certain inequalities, then our engagement with political processes can undo draconian laws, can undo, and a number of these legislations which would stifle dissent. Modifications to the Constitution. So here we are talking about legislations There was a question about modifications to the Constitution. Again, this is something that Dr. B.R. Ambedkar has talked about, in which, while responding to the opposition from the socialist and the communist parties, is saying that, look, we understand that the opposition is understandable, but then there is a procedure for amendment within the Constitution. And to answer the question, can there be modifications to the Constitution? Yes, there can be modifications to the Constitution. Up until now, there are more than 100 such constitutional amendments. And the text of the Constitution, there can be a modification. Which of these should be modified would depend on what is sought, what kind of a change is sought. For example, more recently, we see the amendments on the lines of introduction of a category as economically weaker segment. That has resulted as an outcome of amendments to Article 15. And what that does is that it broadens the protected categories, and it includes a category as EWS, economically weaker segment, within the constitutional frame, which up until that point had not recognized this economic disadvantage. Now, that is something that remains a matter of judicial scrutiny and is being challenged, the constitutional wires of it. And those cases would be intense sites of the application of basic structure doctrine. But that is to say that, yes, modifications are possible, but every such modification would have to be justified, would have to be verified within the parameters of what is permissible as within the basic structure doctrine, so that any modifications of the Constitution should not breach the basic structure. We know that a landmark decision as that of Indra Sani in the early 90s had sought to examine the constitutional validity of a government memo that had sought to introduce reservations for the other backward classes within central government employment. And what transpired was a validity of these reservations for the other backward class category. Along with that, there was also the introduction of this idea of creamy layer. Again, because we are talking about routine language, routine conversation. In routine conversation, and this is something that comes up within our classroom discussions, this idea of creamy layer. When we discuss affirmative action, there is any concession, or there is any reception, a popular reception within the classroom settings in which students would be okay with the idea of affirmative action, but very strongly opposed to any affirmative action being offered to this creamy layer. And this is not just a common popular sentiment. This is not just a matter of routine conversation, although you can find it there as well. But it is part of judicial discourse in which Indra Sani introduces this idea of creamy layer within the text of the decision. And then that becomes a matter of constitutional amendments to follow. Especially the whether or not there can be reservations for scheduled caste, scheduled tribe in promotion is something that is clarified by way of constitutional amendment modification. That comes to be examined in N. Nagaraj, Supreme Court decision that upholds the constitutional amendment, but places a number of conditions. One such condition being that of creamy layer. And that remains a point of discussion in the Ashok Kumar Thakur case, in the Jarnail Singh case. And the reason why we are listing these out is that when we discuss the possibility of constitutional amendments and modifications, then there seems to be a back and forth, a contestation between parliamentary process and a judicial process, in which there is partly an advancement of affirmative action from the parliamentary process, and there is a curtailment or a retrenchment of that advancement in the judicial process. And these processes have come to play in the site of clarifications that was being asked by one of our attendees. And the last area is that of satyagraha and anarchy, especially as we understand satyagraha as some of the ideological characteristics of Mr. Gandhi. We know that there's something which is being opposed, and what is the basis for it. So when we talk about why Dr. Ambedkar is opposed to this grammar of anarchy, is based in the supposition, is based in the idea that the new government of India, in the independent India, in the free India, in the liberated India, would be different from the colonial British government, which had oppressed the population and exploited the people in the subcontinent. But there are critiques which say that there is a post-colonial continuity, in a way that the present government of India has inherited a governmentality of the colonial time. What does that mean? That the people have changed, but the function of the government in oppressing its people has remained. That is quite a profound and troubling idea for us to carry. That is not an idea that Dr. Ambedkar has in mind when Dr. Ambedkar is alerting us against a grammar of anarchy. And when we understand Dr. Ambedkar, we also have to understand that he's somebody who resigns from his cabinet position because of the inability of the government of the day to pass what we know as the Hindu Code Bill, to take any concrete steps for safeguarding the interest of backward classes. So within a span of few years, as that of 1949 and a few years to follow, we know that there is going to be a certain opposition that Dr. B.R. Ambedkar is going to make when he will deliver his resignation from the cabinet position. And then, of course, in a few years' time to follow, there is also the embracing of Buddhism. So what that does is allow us a range of, I'm not saying that this is how multiple consciousness could be understood. It could be one way for us to understand that any proposition that is available to us is something that could be differently understood in its spatial location at the time with its given coordinates. And the given coordinates is the idea is that, look, there will be a rupture. There will be a rupture from the British colonial governmentality to this new governmentality that would be a departure. But if there is a government that continues to be oppressive, that continues to emulate the oppression of a colonizer, then the protest, the protest against, or even then with the engagement, what there is a prescription in Dr. Ambedkar's idea is that there should be constitutional methods. And those constitutional methods would be to engage within a more transformatory potential of the Constitution. So is there anything else?
We have one more question coming up. When you mentioned about reservation, we had one question coming up from one of the attendees, Anurag Shirsagar from Ramnarayan Roya College. His question was, the political reservations were initially meant for a few years, but then they were extended and they are still being extended, maybe due to political reasons. So similarly, the reservations in different fields, should they be continued forever or they should be amended in the present scenario and given on economical grounds?
Good question.
Oh, I'm so sorry. May I speak, Soumya? I think there is
Yes,
one
sir,
more
please.
question. This from a friend of mine, Dipanjali. So I would like to read this question here. So can we take this question along with this question, Sumit?
Yes, please.
Yeah, I'll read this out. Apart from the fact that the Indian society is stepped in a caste-based societal framework, what are some other differences vis-a-vis other countries that Ambedkar had in mind while drafting the constitution?
Could you please repeat that question? Sorry.
Yes, 1 minute. So here Dipanjali asks, apart from the fact that the Indian society is stepped in a caste-based societal framework, what are some other differences vis-a-vis other countries that Ambedkar had in mind while drafting the constitution?
Good. Okay, so I think that these two questions are in a way interrelated. We'll take the latter question and then we will proceed with this understanding that reservations were meant to be time bound. When Dr. Ambedkar's 1949 speech is referring to the inequality in the United States, for example, and is referring to that inequality to say that, look, with that inequality, the US didn't have a caste system. But what the US did have is a deep and pervasive racial inequality. And the making of the Constitution after the American Revolution was such that it did not consider this race-based inequality. And even the understanding of citizenship was limited to white men. So then, with this kind of a deep and pervasive racial inequality in the very text of the Constitution, but it is also differently located in time, right? By the time it's 20th century, it is post-Second World War. And post-Second World War also by the, what is coterminous to the making of the Constitution is the Universal Declaration of Human Rights. So at this point, there is a robust understanding of the various forms of inequalities that there are. Now, more critical thinkers as Hannah Arendt, I'm not sure I'm pronouncing the last name correct, have argued that constitutional processes are better off without engaging with any kind of inequality. And perhaps the success of the US Constitution is precisely because it did not engage with the question of racial inequality. With that, can we say that maybe the Constitution of India should not have engaged with the question of caste-based inequality? And but then, because the US Constitution didn't consider the race-based inequality, what follows is a civil war, a bloody civil war in the mid-19th century. And that question of race-based inequality is front and center. And then what follows is the 13th and the 14th Amendment to the American Constitution. All of this would be something that not just Dr. B.R. Ambedkar, but the Constituent Assembly and all those who are involved in political processes would be familiar with. Many of the statesmen at the time had been educated in parts of the world as England. So there was we can assume that there was a robust understanding of what is happening internationally. And much of that has, yes, contributed to the Constitution of India. And often it is said that Constitution of India does build on the German Constitution, it builds on the American Constitution, it builds on the Australian Constitution. So it borrows from existing constitutional ideas and is therefore eclectic in the sources in which it draws from. A very commonplace understanding of reservations is that it was time bound. It was time bound for 10 years, and after then it was supposed to have come to an end. And this commonplace understanding needs to be corrected because, even if there is any reference to this time bound nature of reservations, it is with reference to reservations within the electoral constituency, therefore reservations within the parliament, within the legislative assemblies. And the time-bound nature is such that it is a matter of democratic process for the parliament to renew it. And what happens is that it has been renewed on a recurring basis. But often when we say that, this idea of reservations was time-bound, then we have to understand that it is within the specific domain as that of reservations within parliament. Whereas when we understand reservations within, say, educational institutions, within employment, there is no understanding of that time-bound nature. Rather, when we understand reservations, when we understand affirmative action, it is related with the experiences of inequality and discrimination. So long as there is inequality, so long as there is discrimination, what affirmative action does is a remedial measure. It tries to correct the discrimination that there is. It tries to address the inequality that there is. So when we understand affirmative action reservations, we have to understand it in relation to the existing forms of inequality and discrimination that there is. Why is it that the municipality workers who sweep the roads are all of a particular caste denomination? Is it by default? Is it a natural order of things? Or is there something more sinister at play that makes it compulsory for a certain caste constituency to do things like sweeping the roads and cleaning the roads, whereas the entire function of priesthood and temples, a whole economy, is something in which there is 100% reservations? And those areas, those are not questioned when we understand reservations, when we understand affirmative action. What we don't engage sufficiently with is some of the existing forms of inequality that are around us for us to see, but often it just needs to be brought to our attention and discussed more clearly. And any discussion of affirmative action should attempt to do that.
Adding to his question about your the description about reservation, he asks that how since a reservation was only in for the parliamentary elections, how long do you think that we need to continue the system of reservation?
Within parliamentary domain?
In general.
In general, then how long we need to have affirmative action would be a factor of inequality and discrimination. So long as there is inequality and discrimination, there needs to be affirmative action. Why? Because of the ways in which systemic structures work on us, and it places us unequally. So for us to do away with reservations, for us to do away with affirmative action, we have to do away with the discrimination. We have to do away with the inequality. And again, I'm invoking a iconic text by Dr. B.R. Ambedkar titled Annihilation of Caste, in which one of the prescriptive note on which that text ends is that of annihilation of caste by intercaste marriages. This is a piece of 1936. And even now, many of you would have seen the matrimonial segment in newspapers, national daily newspapers. There'll be a whole page which will organize matrimonial alliances, which will be sought on caste lines. Brahmin, and then there will also be a period of clearly seeking, there would be a matrimonial alliance that would be sought within the caste. So when there is a caste composition, which is secured by way of marriages within caste, then there is a embedded, caste is ingrained in the social fabric such that there is a deep and pervasive inequality. Now what we are talking about, love jihad, and the attempt to prevent interreligious marriages. So the sentiment which attempts to to maintain its purity, so to speak, on the lines of caste, on the lines of religion, is not a thing of the past. It remains. So when there are such sentiments in which there is a part advancement of, what did Dr. Ambedkar say about the democracy being fragile? Or what is it, why is it that this independence of India is fragile? Because we are divided. Because we are divided on the lines of caste, because we are divided on the lines of religion, ethnicity, language. So for us to be unified, there has to be securing of democracy. How can democracy be secured? Through constitutional methods, by not hero worshipping any leader, and third and last, by social equality, both political equality and social equality. How can that be done? By the Trinity, union of territory, which is equality, fraternity, liberty. So the question about affirmative action, the question about reservation is a question about equality and inequality. Therefore, any answer to how long affirmative action and reservations would continue would be factored on, would hinge on the continuity of the inequality and discrimination that there is. So that in pursuit of equality, in pursuit of non-discrimination, there has to be an end to this inequality. There has to be a non-discrimination for any kind of affirmative action and reservation to come to an end. And I think that would also be a note on which we could bring this session to closure. Unless I'm available, we had scheduled a time as up until 7, but if more of us want to continue, I'm very happy to have this conversation. I'm very pleased to engage with the political science department, with the organizing team, and with all of the attendees.
So I just have one small question. Like you said, reservations is, it's because we are divided. But don't you think reservations based on caste, they lead to further divisions in society? Because it's not really fair. It might seem unfair to others, maybe for admissions or anything.
That's true. And one of the arguments that is made against reservations is this, that what reservations do is that they further secure and deepen caste-based identities and caste-based groups, and it generates a resentment against the very reserved constituency that is then able to avail of facilities such as employment and education. And the argument that is further advanced is this, that look, rather than do any advantage to those within the reserved groups, it does more disadvantage because of the virulent stigma. But why is it? We must ask, why is it that there is a virulent stigma? Why is it that there is a feeling of resentment? And that might be because of, again, we're going to connect it to the topic of this webinar, which is that of routine conversation. In routine conversation, we often use the word benefit, isn't it? When we say, and in Hindi often it is said, इन्होंने फायदा उठाया, इन्होंने reservation का फायदा उठाया, isn't it? Likewise, in English, the word benefit is used, and it is not just a matter of routine conversational usage. We find this usage even within the judicial discourse. But it is not a usage that we find within the Constitution, which only allows for certain provisions to be created. So rather than say benefit, can we say that some groups avail of facility of affirmative action? What it would do is it would undo the kind of resentment that some of us might feel for anybody who may have benefited. Because when we use benefit, it is often understood as an unfair benefit. We use
advantage.
So there are many things which are there in our conscious and unconscious usage of language that could be attended to for us to address and understand this differently. Because if we continue to place ourselves in a position of resentment against any other group, it would be harmful to us and it would be harmful for the group. We have to be able to understand the function of equality, especially within the constitutional judicial discourse, which has clarified that any affirmative action, any reservations is not an exception to the principle of equality. It's a provision of equality. And often in our study of constitutional law, this point within the judicial discourse is something that we spend a lot of time on, because even students of law often struggle with this idea that reservations are not an exception to equality, rather, they are a provision of equality. So that means it is not that an exception or an exceptional advantage is being given to anybody, or an exceptional benefit is being given to anybody. Any reservations, affirmative action is a function of equality, is a function of doing away inequality. And with that, when we understand reservations in its relation to equality, and also when we displace the language of faida and benefit, then perhaps we can also partly displace any sentiments of resentment that we might harbor against any group that may be sought to be made equal. And that could be one way of understanding affirmative action and reservation. Having said that, understandably, there is a polarity to this question. So, there is no way in which within the time of this evening, even if we were to extend this webinar all night, we would get to any kind of conclusive understanding. And there is a reason why there is a polarity. It is not a easy issue. It is not something that can be resolved within the time span of a few minutes. So long as we keep an open mind, so long as we continue to engage, I think it's a productive process. And this webinar is one contribution toward that.
Thank you so much, sir, and wishing you a very happy Constitution Day.
Thank you. So wish you a very happy Constitution Day to all of you. Thank you very much for the efforts of the organizing team. Thank you very much, Professor Samarjit Padi. Thank you very much, Dr. Vritant, for inviting me to this event. It is wonderful to gain acquaintance with the KC College and with the Department of Political Science. I wish you all the very best. It's very encouraging for me to engage with the young minds as yours. And I hope to hear more of your accomplishments and your successes to follow. I wish you all the very best. With that, I'll hand it back to the organizing team. Thank you.
So we actually have a concept note from one of the students. I'll request Uttam Jaiswal to come up and speak.
Thank you, Soumya. A very good evening, everyone. I'm overwhelmed to be here and speak on behalf of the students. Am I audible?
Yes, you are.
Okay, thank you. The Constitution serves as the rule book for our government. It establishes what cannot and what authorities can do. The Supreme Court has ruled over government choices several times in an evidence of this. Being a political science student, I would love to state that students in India should know their legal right. That is, right to freedom of speech and expression, stated in Article 19, right to information, stated in Article 19(1), right to equality, stated in Article 14A, right to education, stated in Article 21A, right to life under Article 21 of the Constitution of India. The Constitution serves as same ideals which our society should live by. People on all sides of political disagreements try to work with constitutional ideals to protect their side of an argument. Nowadays, the Constitution is used both as a legal document so that as a group of ideals in our society. Constitution states its principle for people from different backgrounds. Some other roles we see every day are freedom of speech, freedom to choose a religion, belief of one's own choice, right to carry arms, freedom to travel. The Constitution plays numerous parts in our society. Studying the Constitution is important because each generation needs to know not only the rights and privileges granted by Constitution, but also the obligations of its citizens. The Constitution is an instrument of control because it assists the government to control itself and helps a government. It can help by separating forces of three hands of the government in setting restrictions for the executive, for the judiciary, and for the legislature. The Constitution performs an important role in guarding human rights as contained in the fundamental rights. Thank you. That's all what we students what I would like to speak on behalf of all the students.
Thank you, Uttam. Thank you for the informative conceptual note. I will request Dhruvi to come ahead and give the vote of thanks.
Good evening to all. Am I audible?
Yes, you are.
Okay. Honorable dignitaries and most valued guests, it's my privilege to propose the vote of thanks on behalf of this esteemed institution. I would like to express my gratitude towards the speaker, Sumit Botsar, who has spared his precious time for us and graced this occasion with his inspirational thoughts. I extend my sincere thanks to the principal of KC College, Dr. Hemlata Bagla Madam, for being our backbone in our endeavor and constantly motivating and inspiring us. Thank you to Samarjit Padi sir for joining us today. I would like to thank the former HOD of Political Science, Shushma Pandey Madam. Thank you to Assistant Professor Dr. Vrittant Manvatkar sir for organizing such an amazing event and making it a successful one. I would like to thank our staff members, students, participants, volunteers, Soumya, Stuti, Uttam, convener Shakshi Sachadev, non-teaching staff, and last but not the least, our beloved audience for making this event a grand success. Thank you so much all.
Thank you, Dhruvi.
Thank you so much, Sumit sir, for being here. It was a great pleasure to hear you.
Thank you so much, all of you. Thank you, Sumit. Thanks. It was a pleasure joining this webinar. Thank you very much.